I'm going to ask the speakers to come up now. If anyone wants to leave before this proceeding, by all means. The rest of you, why not come down a little bit closer and let's get into it all together. These really work well if you participate. Look, if the speakers come up, then I'll ask Rod to take the chair.
Hi, how are you?
Good to see you.
Hello, Andrew. Hi. Hi. Great day. Great to see you.
Rod, do you want to call us up in turn?
No, I think you should all come up. Make it like a family photo or something.
There's more of us up here than there is out there.
There are more chairs here. We can spread out.
Hi, Colin. Just a little inch away from Darius. How far can we go without falling off the edge here? I fell over back. That's right. Squeeze Jay off the edge of the turtle.
Here, you sit here.
Exactly. Right up the edge of the... Oh, yeah?
Get this over with. Did we actually look in the question box, Mr. Chairman of the day? Aha, as you suspected. Well, we have a couple of so-called prepared questions to get things started off. Why don't I start with one of them? With respect to a matter that you think is urgent, under what conditions can you get a judicial review application on, I think, before a weekly court judge? What does urgency mean today? Glennis, Steve, Colin, whoever wants to start.
Well, I think urgency means, first of all, that you initially must not have delayed in bringing your application. In other words, if you're going to go to the weekly court and say the matter is urgent, if your client hasn't come to you for 6 weeks after it happened, you're not probably going to have an urgent case. The one that I'm familiar with is the Peralta case, where challenge to the fish quotas for commercial fishermen in Lake Erie during the fishing season. Therefore, any delay in going to the divisional court would have involved a failure of justice, because the fishermen were out fishing, they'd already invested for the year's catch, etc. So that clearly is a situation where you can't wait. And I think the weekly court judge probably doesn't want to hear a case in the first place. He'd rather have the divisional court hear it, so that you're going to need to have pretty good reasons why your client is going to be adversely affected, so that you can argue the fact that it needs to be heard by the weekly court judge.
Rod, last time I checked, there is a duty judge who is one of the high court judges, supposedly otherwise on a judgment week, that is supposed to be available to deal with matters of procedure, and that can include a very urgent matter. But I can tell you, you've got to be able to prove absolute urgency. Other than that, if you call up the weekly court office, they'll tell you the next appointment's in 3 months.
The time that I've had to deal with urgent matters, the basis of most tribunals is a public interest statute. And where there is a public interest statute, it's often involving more than just one party. And where it involves matters of state importance or large numbers of people, you can rely upon that and the public interest nature of your tribunal's decisions to, one, get a single judge to hear it, or oftentimes the divisional court will set a panel of 3 at very short notice if you can be persuasive and get a special appointment. So that one way or another, if you have the kind of circumstances to which I was making reference, you'll get an urgent hearing, oftentimes within a week.
Further comment?
I can just add, consent doesn't necessarily help you in any way on this particular route. An interesting wrinkle that I've come across is we actually had, in effect, a hearing in chambers, which was in essence a pretrial on the issue of urgency before Mr. Justice Reed, a complicated environmental matter where we addressed the issue before him as to whether this was a matter which should go by way of Section 6.2, an urgent application, or should be dealt with on an expedited basis by a specially designated panel of the divisional court.
I hesitate to throw this in, Rod, because it can only make my life miserable, but the trial division of the federal court has recently discovered the telephone as an instrument by which to hear injunction applications. And I'm told one a couple of weeks ago actually lasted about 4 hours with one counsel in Toronto, one counsel in Montreal, and a judge in Ottawa, and eventually no injunction. But it's interesting that you can get a hearing on very quickly. A big phone bill, and presumably you can send the paper around by fax too, so that there's nothing the least bit impractical about telephone hearings.
I was going to bet, though, that the applicant has an extraordinary disadvantage in not being before the court. The telephone, I think, would militate against granting an injunction.
I think that's always true of whoever has the burden of persuasion. That
Depends where the
it's
judge
better
is.
to be
though.
there.
If you're the only guy before the judge, you got one up.
Fair. Yes, indeed. That's right. If you've got the other guy on the telephone, that's right.
Okay. We've got a couple of charter questions that I'd like to address to Jeff first. Perhaps do one of them now and then move back to the other stuff. In your paper, Jeff, on page 5, you made the point that Section 7 is in effect a general section of the charter, and that sections 8 to 14 of the charter that follow are but specific examples of the principles encompassed by Section 7. When the charter was being drafted in the summer of 80 and through 80 and into 81, there were a total of, I believe, 7 earlier formal public versions of the charter. The first 2 prepared by the federal government, then a provincial response, and then a 3rd federal draft, and then the series that went before the Joint Committee of the House and Senate. And in that first federal draft, what is now Section 7 and Sections 8 to 14 were in effect in one section, and it was a basket clause, and what is now Section 7 was the preamble to the basket. Does the fact that that was in that draft and the fact that it wasn't in the next 6 drafts and isn't in the final version, how do those factors affect the point that you make on page 5?
Well, I can't recall specifically whether in the Motor Vehicle Act case, which this reasoning comes out of it, they went into the legislative history.
I don't think they did.
I don't think they did. You could argue that point, but I think the decision of the Supreme Court has in essence said implicitly there is a point in that distinction. They have separated these rights. And as I indicated earlier, the rights found in sections 8 to 14 do have various internal limits built into them. Section 11 is predicated upon someone being charged with an offense. So that doesn't make it applicable to certain kinds of proceedings. And I think what the Supreme Court has done in the BC case is said those other sections provide and constitute particular rights, but we nevertheless have this power in Section 7 of substantive review of legislation for generally badness. It just doesn't smell right, and there's nothing in our common law traditions that suggests it should be upheld. So it truly is a residual section with an all-embrace of substantive content to it. Now, there was a great academic debate over whether it should be restricted to procedural due process or encompass substantive due process, and the Supreme Court has decided the latter.
Any other comments, panel members, on that? The fact that we have a few of these canned questions prepared, don't let that discourage you from jumping in yourself. Please, what about, let's go, I'm sorry? Yes?
I have a question with regard to charter litigation and the issue of public standing. In public interest litigation, it seems in the trilogy, Thorson, Neil, Borowski, and Finley had an individual plaintiff who was raising an issue that they felt of general public interest, test case litigation. Is there any advantage to having an individual plaintiff as opposed to, say, a group plaintiff? For example, an operation was now you have a whole bundle of plaintiffs coming together. Is there any procedural advantage, or has there been perceived a willingness to listen to an individual plaintiff raising a case as opposed to a bunch?
Well, you've got one of the experts on this panel, and Andy Roman, so I'll turn that.
Yeah, I was one of the counsel in the Finley case, so I can tell you there that I think it had a great advantage in that we were dealing with a real individual who was living on welfare and had his welfare reduced to below the subsistence level, and so nobody could suggest that he was just monkeying around. He had the most traditional kind of interest involved that one could possibly have. The difficulty with Operation Dismantle, though, is that it wasn't thrown out on the grounds of standing. It was more or less what you might call a justiciability question. And I'm not familiar with any standing case where a group has been treated all that differently from an individual, so I don't think you get the answer out of decided cases. But just intuitively, I think that the more pathetic and painful the circumstances are to the individual, the more likely you are to obtain standing for her or him, and the more the person has an academic interest, obviously, the less likely. The interesting thing about Thorson, I think, was that had he been anything other than a retired judge, he probably wouldn't have got standing. But since they all work in the same building, it's very difficult to throw out your colleague.
Can I add to that, Andy? This isn't directly relevant to your question, but it's perhaps close. When the government of Ontario decided to intervene in the U.S. Court of Appeal in Washington in the acid rain suit between the New England states and the U.S. EPA administrator, our decision was to intervene in the name of the Attorney General, but also a selected citizen who had a cottage in Muskoka and whose dock and whose furniture and whose lake was affected by the acid rain question in issue. And I think that helped us in obtaining standing in the U.S. Court of Appeal.
So you would suggest that even if you do have a group plaintiff, that there is advantage also in having individuals who have a demonstrated very specific interest there as well?
I think it may depend on what you're challenged, what section you're challenging, and I don't really know what you mean by a group. But for example, if you're challenging extra billing, if you're just challenging with respect to the Ontario Medical Association or the Canadian Medical Association and you're using Charter Section 7 and Charter Section 15, I think you have a real difficulty unless you have some individual doctors or patients involved.
I was just going to add that in regulatory proceedings, if you foresee a charter issue coming up, say an equality issue under Section 15, because Canadian and provincial tribunals, God knows, treat different people differently. If you're acting for a corporate group or an incorporated group, it's always wise to have a couple of individuals who are similarly situated as a corporate group along for the ride so that you can raise the issue with their name if some point is taken about the corporate party or the incorporated group party raising the issue.
Okay. Further comment?
Question over here, Ron.
Yes, sorry.
I just wanted to follow that up. The Finley case was really the first time somebody brought that issue before in that way. And I'm wondering how much that affected your ability to provide standing so that you have, if there are any number of welfare recipients who find themselves in quite similar circumstances. It helps you up to bring an action against Mr. Finance. There's going to be a cutoff, or just because the court's already been exposed, there are already actions in the system. What, in other words, the fact that it's already happened or already been done affects your ability to make a decision?
I think, first of all, it helps to have an interesting case. You're much more likely to want to hear it than one that's boring or one that doesn't raise great, sweeping, interesting questions of law. The other thing, of course, is that there's the other side of that coin is that there's the worry about the floodgates of litigation being open. And what you have to try and do is persuade them that your case is interesting, important, and relevant, but that everybody isn't going to be following you, and that's the tightrope you're dancing. It's so interesting that they've got to hear it, but there aren't all that many people who are going to be coming along behind.
It's a little like the test for getting leave in the Supreme Court of Canada, really.
Well, of course, the people who come along behind can't really satisfy the test anyway in the trilogy because they can't show that the issue won't otherwise get before the court. So, in a way, it's first come, first served if you meet all the other criteria.
Yes. Question at the back?
Yes, I'm wondering if anyone can comment on challenges open to advisory boards. I'm thinking particularly Federal Environmental Assessment Review Agency, which is basically an advisory board to the minister. And they hold hearings and call witnesses. They, for example, say it's non-adversarial, so the really can't cross-examine. I'm wondering if any of the panelists have had any experience with that kind of a situation where it seems like it's quasi-administrative and these are the normal challenges apply in those situations.
Andy?
On the one hand, you run into the problem of the tribunal being the master of its own procedure and the court being reluctant to interfere because if they find it more convenient, let's say, to have Inuit witnesses appearing before them without being intimidated by lawyers cross-examining them, then the court is going to be reluctant to interfere with them adopting that procedure. The other side of the coin, though, is that merely because they're advisory does not mean that you can't get some judicial review. There are lots of cases that say you can, especially if there is likely to be a decision made by somebody relying upon that. ABLE and the Advisory Review Board is one example of a case like that, where you can be very sure in your environmental case that the relevant minister is not going to simply toss the, or most cases isn't going to toss it in the garbage, but is going to be very heavily influenced by the expert panel of 5 people who have traveled all over the Arctic to find out about this particular project. So I think judicial review is available, but it's difficult to get on the narrow procedural ground that they failed to adopt court-like procedure. There has to be something more, and I think it's closer to what John Campion said earlier, that you have to show that some right of yours was very seriously damaged by virtue of that procedural peculiarity that the tribunal chose to employ.
There are 2 very recent examples of that in the federal court right now. One is a case in which Monsanto was the subject of a long hearing before an environmental board which advised the minister. They brought proceedings in the Federal Court of Appeal by way of judicial review. The court refused to quash that for absence of jurisdiction. They haven't heard the merits yet, but presumably they've decided they at least have jurisdiction if they can find an error. The other one that was recently decided by the Federal Court of Appeal is a case called Thompson, I think probably not reported yet. Under the Canadian Security Intelligence Act, there is a review of the denial of a security clearance by the Security Intelligence Review Committee. And the words of the statute are that after a procedure that's much like a trial, that committee recommends to the relevant deputy minister. And the Federal Court of Appeal in the recent judgment decided that that word recommend really means decide, because the deputy minister is bound to follow the recommendation. And they granted judicial review in that case. I guess they refused it on the merits, but they found they had jurisdiction.
Okay, can we move to another charter question that I'll ask Jeff to comment on first. The remedy section of the charter, section 24, says that you can have a remedy if your rights, and the words are, quote, as guaranteed, end quote, by the charter are breached. There's an argument that that word guarantee refers back to section 1, where the verb guarantee is used. Prior to the charter coming into force, the Attorney General of Canada and the provincial attorneys general got together and decided that the tactical or strategical position of the Crown in Canada in criminal cases should be that because of the use of those words in section 24 and section 1, the onus with respect to section 1 of the charter lay on the applicant. The theory being that the only thing he can get a remedy for the breach of is the right as guaranteed, and the right is only guaranteed subject to certain limitations in section 1. As it turned out, the first major case, I think, that came along was the Quebec Protestant School Board Association versus the Attorney General of Quebec, where the federal government intervened to support the Quebec Protestant School Board Association. And so if the federal Attorney General followed through and took that position, it would mean that he was in the position of having the onus. and he decided for that reason and perhaps others not to do that. So that issue has never been argued, fully at least, in criminal cases. Now that the charter is being used more in administrative law situations, if you're acting for a respondent, is that an argument? There are all kinds of cases, Raucus, Southam, Oaks, where the conclusion is made that the onus is on the Crown, traditionally the respondent to the charter application. But the reasoning process is not explored, to my knowledge, in any of those cases. As a respondent in an administrative law case involving an application of the charter, is that an argument that's open to you to make? And if so, does it have any chance of success?
I suppose it's open to you as the applicant. I'd be delighted if you made it on behalf of the respondent, because I think it can be shot down very quickly. With hindsight, mind you, given the Supreme Court of Canada's reasoning in those cases. And I think that goes to essentially the structure the Supreme Court has placed upon the interpretation of the charter, and that the onus is on the applicant to demonstrate that some right or freedom has been infringed, and that the applicant must meet that particular test. But then, having demonstrated a charter infringement, the words demonstrably justified in Section 1 throw that onus back on the respondent, and that's where it rests. I can't see our courts now attempting to weave their way back into the statutory and legislative history of the charter to give that argument any real support.
I think you're for it as an ex-Crown representative to justify every breach of the charter under Section 1.
Okay. Any other comments on that? Eric, tell us about the federal court system. Do the judges sort of lean to favor the government of Canada?
If they do, I haven't noticed it. No, I don't think they lean either way consciously. I think, to the best of their ability, they deal with the issues as they see them without any leaning one way or the other. I think the court is perhaps sensitive to the fact that it is viewed through some people's eyes as being a, quote, Crown court. And perhaps they're a little sensitive to not give that perception to the community and the bar. I don't know whether Andrew Roman would agree with me or not. He's been in the federal court a fair bit and seen it from the other side of the courtroom.
Would you describe all those ex-Liberal cabinet ministers as applicants, judges?
The irony is all the people you think would be pro-Crown, including a lot of people from Eric's office, are not. And all the ones you think wouldn't be are. So there's no way to predict these things. It really makes you wonder whether what the Americans go through when they're appointing people to Supreme Court justices positions has any purpose.
Both Steve and I were involved in a case, cyanamide bypass pipeline for gas in Ontario. The National Energy Board decided that it had jurisdiction to determine the right to construct such a bypass line in Ontario. The Ontario Energy Board, in companion proceedings, decided that it had jurisdiction. That went to our divisional court. The NEB reference went to the federal court, and it was sort of everybody's feeling that it would be best for those of us who were trying to uphold the Ontario Energy Board's jurisdiction that we make sure that we go to the Supreme Court of Canada with a Court of Appeal decision in Ontario, rather than going with a federal Court of Appeal decision in the Supreme Court of Canada. But before the Court of Appeal, after it was referred to our Court of Appeal, before the Court of Appeal in Ontario gave its decision, the parallel proceedings went in the federal court, and the federal court found for the validity of the Ontario Energy Board's jurisdiction. So the whole thing sort of came back to haunt us, and everybody was rather surprised that the federal court would uphold the jurisdiction of the Ontario board rather than the federal board.
Of course, as a longtime federal court observer, I think that that was because they knew that everyone was watching them. I made the point in these proceedings, and I think we're going to take an empirical study, which someone should do from some law school sometime, find out that if you are acting for someone upholding a government decision, you breathe a lot easier in the federal court than you do in the divisional court of the Ontario Court of Appeal. Correlatively, if you're trying to overturn a governmental decision, you work about 10 times as hard in the federal court than you do in the divisional court or the Ontario Court of Appeal. That's a perception. And someone must do an empirical study of the federal court of appeal on judicial review compared to other administrative law courts like the divisional court or the court of appeal to really find out whether there's any real force in that perception. But from the point of view of a practitioner on all sides, I've seen applicants really work hard and get nowhere, and people who have not done a great deal of hard work on the respondent side look victorious. That's a perception.
The exception I'd make to that, Ian, is probably the income tax. I've done a fair number of tax cases, and I found the federal court to give the Crown a pretty hard time, and not particularly to favor the tax court, for instance, when it's an appeal. They look at it de novo, and I think they're pretty tough.
I
They've got
accept
such a
that.
personal interest.
Well,
And I think you have to accept, from my perception, the work of the trial division in almost any of its primary matters other than Section 18 proceedings.
The point was made this morning a couple of times, I think, that if you look for it, you really can find some help from the government lawyers involved on the other side of the coin before the thing actually gets to hearing. And presumably, at both the federal and the provincial level, I'd like Glennis to comment. I would put it even a little stronger than that, that the setup in Ontario, as most of you will be aware, is that the legal branches of the various ministries with whom your clients have to deal are staffed by lawyers who are in fact employees of the Ministry of the Attorney General, but operate exclusively within their particular ministry, and generally speaking are not counsel who go to court on a regular basis. There are some exceptions to that. If it gets to the matter of a judicial review, it'll be somebody from the Crown Law Office Civil at 18 King Street East who will generally take over at that level. My point being that there is a point of first entry at the ministry involved where you can deal with the legal branch there and try and solve it there so that it doesn't get to a stage where it's escalated to the point that it goes to the Ministry of the Attorney General at 18 King. Now, that's obviously not going to happen in every case, but in a large measure, it's in the interest of that legal branch to be able to solve the problem, whatever it is, without having to hand it over to the big shooters down at 18 King. Is that a fair analysis, Glennis, as you would say?
I think that's a fair analysis. I really think there probably is a lack of enough communication between litigant applicants and the respondent Crown. And I think there may be exceptions, but I think you'll find that in most of our law offices, the director lawyers are really willing to try to assist, because it's always better to, if you have to litigate, to go either we're doing a number of cases on agreed statements of fact. It takes a long time to work them out, but still I think in the end result, rather than going through lengthy discoveries, etc., you can save a lot of time, and then the record that you put before the court, the judge is going to appreciate the fact that this effort has been made. So I think maybe it's a lack of communication. The mechanism is there, but it just needs to be used more.
There's one corollary to that, and that is that staff in the various commissions and boards that operate in the province oftentimes have equal influence on these decisions, and the same principle applies, and that is, if you've got a problem, you can oftentimes settle it with staff long before you even invoke the solicitor's side of the Crown Law Office, and long before it ever is contemplated it goes to the Attorney General's barrister's branch.
That's a good point. Steve?
I'd like to ask you two guys who've spent a number of very productive years in government a kind of related question. One of the ways that governmental action of the kinds we've been talking about today can be corrected, I guess, is a way we haven't talked about this morning, and that's using the political route. That is, if you have governmental action that could be corrected, for example, by a regulation or by a political decision of some kind, is that something that's open apart from attacking the decision that's been made through the courts? From the perception of you two guys who both held very senior positions in the government, what's the relationship between those two approaches, and how should they be worked, simultaneously or sequentially? Let me put the precise case. If you have a decision that you want to overturn, and that it could be attacked in the courts or it could be overturned politically, does it damage your political chances to commence litigation, or should you, because the politicians will say, well, it's in the hands of the courts and we won't monkey around with it, or should you try to do both at once, or should you try to do the legal route first on the basis that the politician will respond better after you've tried the legal route? What's your sense of that?
My sense, Steve, would be that in the best of all worlds, you go the political route first. And when I say political route, I mean you go to the relevant public servant first, and you put to the relevant public servant the possible ways in which the problem can be solved, i.e. An amendment, a regulation, or alternatively the judicial route, and invite him to make the necessary inquiries to be able to, of his minister if necessary, to be able to come back to you and say, look, we realize there's a problem. The government would really prefer you to try and settle this in the court first. Or alternatively, he'll come back and say, if he agrees there's a problem, we agree there's a problem, we think we can solve it by a political route, why do we have to bother going to court? Let's try and do it that way. Now, that's the best of all worlds. You may not get that kind of as positive a response, but it's worth a try. And when I emphasize the public servant, the worst thing you can do is accede to your client's perhaps natural and very regular desire to phone the minister immediately, or to let's go and see the premier. There's nothing that offends competent senior public servants more than having people bypass them and attempt to make it look as though it's a partisan political approach.
I might add to that, at the municipal level, I agree with Rod, it's exactly the same thing. I think if you've got a problem dealing with a municipality, even a building code act problem, you're best to talk to staff first, basically so you know what the problem is. Sometimes there is miscommunication between your client and that particular administrative official. Straighten that out first. Then I would advocate the political route. I would speak to the politicians involved next. And the last thing I do would be to initiate the legal action. Once you've started the action, I know the politicians, in my experiences, will not touch it. They'll all say it's a matter before the courts, let the courts decide. So I agree with that.
I totally agree as well. I'm working on a couple of cases now, both dealing with Francophone minority French language rights under Charter Section 23. And the way we look at it is basically Section 23 requires equality. And we have been urging our client, the Ministry of Education, to realize that French minority language rights have to be treated the same as English majority rights. And we don't want to go to court on issues which we feel can be resolved. And in a couple of the cases, what they've done is said, well, we'll give you a notice under the Proceedings Against the Crown Act just to protect our time to get on with it if we have to litigate, but then they come to us with suggestions or options as to how to resolve it, and then we go to our client and get the civil servants involved in saying, look, we've got to find a resolution of this, and then that works its way up to a recommendation to the deputy minister and then goes to the minister. And I totally agree with Rod. I think you make a mistake if you go to a cabinet minister on the first day saying, look, we've got this problem, when you haven't let the staff of a particular ministry try to resolve it for you in the first instance.
You've got every right to go on to the minister if you're not satisfied with the way the public servants handle it. And equally so within the hierarchy of any ministry, you've got every right to progressively go up the ladder to the deputy minister, but give them a chance to answer before you bring the minister in on it. Comment here? Question?
We sound somewhat hard-nosed about this, and sounding a sour nose is the sort of tone of amity between the public sector and private sector. As a town officer, though, I'd be interested in knowing what does it cost to take a matter before the divisional court. I'm thinking of scenarios where I'm dealing with counsel representing a client that's already come to my office in terms of trying to deal with an administrative problem, and they said, well, if you don't do this, we're going to bring an application for judicial review. I want to know when I can call some bluff.
I'd say about 15 grand in an easy case.
That's the number I'd give.
On a complicated, longer one that's going on, like the Canadian Tire case where you went on for days and days, multiply it up.
So 15 grand for a day's...
Days with all the preparation and, all the exchange of factums and everything else. I think altogether it's about 15,000. That's a wild guess, but that's what I normally think of.
Can we go back to Steve's question and Eric ask you, what about the federal government? What's the...
I agree with you completely. And perhaps the worst thing of all is once in a while you see somebody who not only goes to the minister, but every time there's a cabinet shuffle, he's still around and he goes to the new minister, and it does get a little tiresome.
My limited experience is that except for the very exceptional politician who really has power, that the ministers often don't wield much power directly. That it's the staff who wield the power because they turn to their senior staff people, the deputy ministers, and say, what do I do? And or if it requires the Lieutenant Governor and Council, the Cabinet, to meet and make its decision, you really have to choose your minister carefully. But my experience is that your best bet is by far to get all the support here first before somebody gets their nose out of joint and gives, at the staff level, basically puts a roadblock in your way because you chose the wrong process.
But Rod, on Steve's point, there's a timing issue. I mean, you say, go talk to the officials, let the officials get together, and we all know what everyone's date book looks like. It just takes time. People may not have the time to wait until the government makes policy, then drafts a regulation, has it approved, enacted, or whatever. Isn't there a timing advantage to getting government policy made or getting a decision from officials by commencing legal action? I could give examples from my own experience, but maybe you could answer the general point.
Well, I could see that there will be situations where time being as important as it is, you simply can't wait. I guess I couched my answer by saying, in the best of all possible world, try it the way I suggested. You well may not be able to do so in some circumstances.
The real problem for me, Rod, is that my sense is, and it's based on a relatively limited experience, but it's like Virginia's, and that is that the moment you issue a writ or a notice of application, the politician's instinct is to say that is now in the courts, and any political solution is interesting, but we'll wait until we see what the courts do with it.
Exactly, and it's not just the instinct, I think, of the politician, but the staff member in the relevant branch of the ministry who may well have been playing around with a draft of a new amendment that might cure the problem that it got your client into difficulty. He's going to back off even faster than the politicians are.
That isn't to say Ian doesn't raise a valid point, and that is the length of time it takes governments to do things. I mean, that's just a fact of life. But
I think the risk that you take in commencing litigation is that oftentimes perhaps ministers, because of various reasons, would prefer a court to strike down some legislation rather than taking the bull by the horns and doing some amendments. So you take the risk of giving the minister an out by saying, well, I don't want to really deal with that, whereas if you'd gone the route to sort of soften him up and say, look, this is the best thing to do, it should be done, rather than giving him the out and saying, well, I don't want to deal with this, but if the courts strike it down, then I could just simply say, well, the court struck it down.
Yes?
I have a question that's directed now to the entire panel, actually. My knowledge of administrative law is much short length of time than the length of time we've been practicing law, and that I first did administrative law at the law school back in '81. And in '81, our standard administrative law textbook, which everybody uses in Canada, was 99% judicial review of tribunal decisions. And we had one chapter on how to review legislation, how to review cabinet decisions, etc. And the impression that I've gotten, one, over reading administrative law cases since '81, and also especially based on the materials and presentations today, is there's a real shift in administrative law. Administrative law isn't so much now review of judicial administrative review of tribunal decisions. Administrative law is really not a review of government legislation, a review of government action at a non-tribunal level. And my question then is this perception and misperception, or is this indeed a shift in the proportionality of the content of administrative law today?
Andy, do you want to start?
I'd like to start on that. I think it's a function of the teaching of administrative law getting better. When DeSmith wrote his book, it was the first attempt to systematize administrative law, and it was very narrow in its perspective. It's interesting that John Evans at Osgood, who was trying to do a final version, the latest revision of DeSmith, has now had to give up because the concepts in the book, the emphasis on judicial review, has become so obsolete and so narrow that no amount of tinkering with the indexing and the card system is going to fix it. The more progressive law schools now teach not only judicial review, but also questions like how to take on the cabinet or the government in general, the whole notion that's encompassed in Finley. And on top of that, perhaps more constructively, how to present a case to a tribunal. Because otherwise it's like trying to teach doctors by teaching them pathology only and nothing else. So I think what you're experiencing is you're dealing with a bunch of practitioners here rather than teachers of law, and that's why we're approaching it in a different way. And I hope eventually the teaching of law will catch up to the reality in the world out there.
So when you suggest this in '81, it wasn't kind of different than it is today, it's just that the answer that was given was perhaps not representative of what the practice going on out there.
I think that's right.
There's also isn't another point, the point Jeff made this morning, and that is that we now have a whole bunch of new tools given us by the charter. You know, I mean, the charter is now there and has been interpreted or been allowed to apply to things like cabinet decisions and stuff like that you would have trouble attacking under the sort of traditional administrative law notions, but are now really available tools to challenge what government does.
Still, to use the analogy from our title today, deflecting the glacier, it really is an iceberg situation where administrative law, by and large, is practicing before tribunals or dealing with government agencies one way or another. And the tip of that iceberg is judicial review and the principles that control that action or can be invoked to control that action, either under the common law or now with the charter. But how much of our time is spent on actual judicial review as opposed to battling it out in the trenches and dealing with tribunals and government one way or another?
As the organizer of this program, the handful of topics selected for this particular program wasn't arbitrary, but they were chosen from a much larger hand of topics. This is the 6th General Administrative Law program that we've done since 1981. And the first one was all about preparing cases for tribunals. Other ones have been practical legal issues. Another one we focused on how you conduct judicial review applications. And we're back to the sundry practical topics. But there just are a host of high interest administrative law topics that cause problems to each of us regularly in our practice. And next year's list of topics will be completely different, but just as interesting and as remote from just strict judicial review as taught in the law school as these are. So it's broad because government's broad. Government government in Canada is 1/3 of our gross national product. Most people work for it in one form or another. It takes every different form, and each of them exercise powers over people's existence. And lawyers come in contact with them from every angle, inside, outside, and around the hills. So each of those lines of force gives rise to new issues and new problems. And depending on how you examine them, you can throw new light on new areas and raise new questions which need new answers that we can discuss.
Ian, yes.
I'd like to know what constitutes or what determines whether a verbatim record of the hearings is kept or not. What are some of the considerations that should include that? Because not every...
I don't think there's any principle. It's largely custom. It's largely custom.
Well, it's just required, the sheet rack requires
So how...
But only if it's recorded.
not a
Well, if it's
transcript.
recorded, well, not
You're
all
talking
of
about
them
a
record
transcript.
like that.
You're talking about transcript?
Yeah. Well, the Ontario Municipal Board, for example, does not keep transcript evidence.
Sorry?
The Ontario Municipal Board has no court reporter. If you want a transcript in your council before the OMB, you have to order your own court reporter and get your own transcript. Otherwise, there's no record.
Which leads me to the next question I have, which is how do you determine what constitutes the record? Like, what is it you have to get to the various appeal courts to make sure that your case, they understand the case when it gets there?
The record is whatever is written down in paper, and that's why if you don't have and I suppose it includes exhibits if there are such things, but that's why if you don't have a transcript, you're stuck.
And an important exception to that is, of course, the notice of the person who is the tribunal. What does not constitute the record is the notes of the person who is actually sitting there listening to the evidence and taking it. Absent somebody taking it down in a reporting function, I don't think you can get those records.
Yeah, and affidavits purporting to give the evidence before the tribunal, except in very rare cases where the allegation is no evidence at all on a particular point. Our Court of Appeal has said that those will not be permitted. So you're left to getting a reporter there, or in cases where you can't absorb that cost, it's getting as much of your case in on paper. Statements, reports, anything that's on paper, which then becomes an exhibit and is part of the record.
Is there a charter argument to be made for some hearing that doesn't want a recording made?
A charter argument that says you're entitled to make one.
Or demand one.
I suppose you can make one if you want to pay for it. One interesting thing in answer to John's question, which I think a lot of tribunals are asking themselves, is this. Many Ontario tribunals are covered by the Freedom of Information legislation. And that legislation will probably make the notes of the tribunal chairman available. That's something that virtually no tribunal has thought of, the ones that have heart failure.
Where there's a possibility, and I've spoken to some clinics on this, is if you can mount an access to justice argument, and will come more in the context of handicapped or disabled people who require special type of electronic or technology to be able to participate in the hearing, and that will require video streams or some sort of translation devices.
Actually, it was in that context that I was asking the question, because there was a recent administrative law seminar here on handicapped, disabled type hearings, also on other types of hearings where the hearing actually takes place in somebody's home, and there's some feeling on the part of the person conducting the hearing that they want it less formalized. They don't have a formalized hearing. So if I go into one of these situations and I want to bring a paper for it with me and I want to tape what's being said, and the person says, no, I want it, I don't want that to take place. Where from a $15,000 suit, what do you do? What's the argument? Certainly, the normal thing that you would say, access to justice, record, like exactly what you said. I want
It basically comes down to, in essence, a cost analysis. Can you afford the $100 or whatever, $150 a day now for a reporter. The real cost, of course, comes in when you need a transcript for going upstairs. And my practice is usually to say to the client, it's only going to cost you $100 or $150 a day to have a reporter there. And I've had cases where, because of the particular member of the tribunal, as soon as I see that person walk through the door, I get an adjournment so I can get a court reporter there. Because without the reporter, you get some pretty bizarre behavior. But once the reporter is there, all of a sudden the decorum and the quality of the intervention improves remarkably.
Now, the thing to do there is to have your secretary come with a pencil and just sit there and pretend all day.
Well, I'd be interested to know, just following up on that, the rules of practice now provide that you can bring a tape recorder into Supreme Court of Ontario District Court and tape the proceedings as an aid to your own memory. Is anybody familiar with tribunals that would, in light of that, now refuse that aid? I mean, the amendment was put in to aid a handicapped person.
I can't imagine a tribunal throwing you out because you insisted on taping it. And if they did, I can't imagine a court permitting it.
Might reduce the likelihood of his notes being having to be produced pursuant to the Freedom of Information Act, too.
Exactly.
Okay. Yes.
In most cases where the judicial review really amounts to sort of a constitutional review of some piece of legislation, bylaw, or a regulation, what sort of complexion does it give the case where you have had a long consultative process with the affected party, and it's one of the affected parties who is bringing a challenge in creating the legislation? Again, from the perspective of the town officer, would the court be very receptive to knowing that there were month-long hearings or cross-country consultations on this, and this particular group or interested party had representation at this meeting, and maybe raise objections to this particularly offensive section that now he feels is in some ways challengeable by way of judicial review because of uncertainty, vagueness, or some infringement of the charter, but he's on record, at least in the consultative process, as having, had his, well, not his day in court exactly, but certainly his day in terms of the political process that went on before the legislation found its way to the books.
I think the nature of the legislation is important in answering that. It doesn't matter how long the consultative process was if the net effect of it is to deny someone their charter rights or something of that sort. On the other hand, there are a couple of cases involving the CRTC in which late Chief Justice Laskman, where they were dealing with rules of practice or procedure of the CRTC, took into account and applied the principle of curial deference on the basis that the kinds of parties that had regularly appeared there and been involved had been through a consultative process. And in those circumstances, other things being equal, a court should be much more reluctant to get involved than if the tribunal had simply spun this rule out of its own intuition.
I'm actually thinking more of situations where in some legislation you have consultative bodies that are constituted by virtue of state legislation, a board of review or an advisory body to a particular ministry or a particular agency. And most of the legislation passes through them at least at some point. And then a member of their sort of industry or group challenges the legislation on that basis, where that particular individual may not actually have been party to the consultation or to review the legislation. And would that be sort of a burden that this person would have to overcome, of course, to hold that something in favor of upholding the legislation?
I would think that the hardness of the right involved would be the principal consideration and not the nature of the consultative process.
Andy, I could see the consultative process being relevant evidence for purposes of Section 1 of the Charter. If the government is using the fact that they consulted to justify the reasonableness of the legislation, it could be one relevant piece of evidence in that way.
It's slightly different, but that process can give rise to procedural rights if there's been some violation along that process before the legislation is created. because at common law, there's no duty on the legislature to consult, basically. However, there's now a line of cases that's come out of England which says once you've embarked upon that process, however, and you've created a legitimate expectation, you're entitled to enforce that through the courts. And it flows out of the estoppel cases and the Liverpool taxi line of reasoning. And, there's no obligation to do it, but once you embark on the process, that will crystallize certain procedural rights.
I guess the other point I'd make is even if there was some slight disadvantage that you might experience in subsequent court proceedings challenging legislation, because you had participated in the consultative process, don't let that deter you. Your chances of influencing legislation before it's made, if you make good points, is much greater, in my opinion, than your chances of having a court set aside a piece of legislation on division of power and return grounds. So, by all means, consult, make your points, and talk to them as long as they'll listen. They're going to give you something in that process.
And then
the nature of it. Pardon me?
And then sue them.
Then sue them. Ron, I wonder.
I think it is time. Thank you all, panel members. Ladies and gentlemen, thank you.